Before you do the inadvertent disclosure assignment and the discussion board, I wanted to quickly review Federal Rule of Evidence 502. In the previous discussion lectures online, we discussed the Carbis Walker case, which is the current state law. The federal rule is a little more streamlined, and so decided to use this as our guide in figuring out whether or not a court should or should not waive privilege when there is a disclosure. So the three things you really want to focus on is parts A, 1, 2, and 3 of this rule. So under the Federal Rule of Evidence, inadvertent disclosure will not be a waiver of privilege, meaning privilege would still attach to those materials even though they were sent to the other side. And that means the sending party would get those documents back or they would have to be destroyed, but the other party could not use that information unless at some later point they came into possession of that material through appropriate discovery or other measures. So first you have to prove the disclosure is inadvertent. So this is a little more than just saying, oops, we didn't mean to send those documents to the other side. And I think it really ties into the second factor there, that we took reasonable steps to prevent the disclosure. And so when you take reasonable steps to prevent the disclosure, that's going to help you show that it was in fact inadvertent. If we don't have any measures in place in our office when we are sending emails to clients, emails to opposing parties, emails to whoever is relevant to the case, when we don't have proper measures in place to deal with how we're going to respond to document requests and other requests for information through the discovery process, and how we're going to make sure that we're only sending discoverable information and not privileged information. If we don't have those in place already, it's going to be hard to argue that the disclosure was in fact inadvertent, because if we weren't doing anything to protect the material to begin with, then it seems like there's a good argument that it was an intentional disclosure, or at least a negligent disclosure, as opposed to a true inadvertent disclosure. So what you want to look at in any scenario is what steps were taken. And it has to be reasonable steps, okay? As you read the case for the discussion board and as well as for the assignment, we're not looking to see, did the sending party do absolutely everything in their power to prevent it? We're looking to see, did they take reasonable steps to prevent disclosure? Especially looking at things after the fact, it's really easy to be critical of what was done or not done. But again, we're looking at, were there reasonable steps? If we go into court, can we argue that we had these reasonable steps in place? Can we truly prove it was inadvertent, that it was an accident, it was a mistake, it wasn't gross negligence on our parts, to use a legal term, but that it was in fact just something that, despite all of our precautions, it still happened. And that's how inadvertent disclosures generally do occur. And then the third factor, which is one of the most important ones under the Carbis Walker test, is that we took the holder of the privilege, the sender of the information, took prompt, reasonable steps to rectify the error. And then it also refers you to the other rules of civil procedure, and you can certainly look up at those to see if that gives you any more guidance when you're applying it. But what did we do once we found out about the error? And again, very important, I want to stress that it's that the time frame in question is from when we found out about the inadvertent disclosure, or reasonably should have found out about the reasonable disclosure, until the time we take action. That's what's going to determine if it was prompt, because in these cases, a lot of times the inadvertent disclosure is not made known to the sending party, the holder of the privilege, until weeks or months later. That's not the time frame we're looking at. We're looking at, did they take prompt steps to rectify the issue when they learned about the inadvertent disclosure, or when they should have learned about the inadvertent disclosure. So that is the time frame that we're going to be looking at. So when you apply this rule in the assignment, you want to make sure that you are applying all three factors in this rule and that you're being very specific how you would apply those factors. And same thing in the discussion board, although the discussion board is much more broad. You don't just have to focus on applying this rule, but because there's a lot of other aspects that the discussion can go and it would be fine. But make sure that you understand this rule, you understand what an inadvertent disclosure is, how that interrelates to whether privilege is waived, and how we're going to make the best argument for our client if we do inadvertently disclose information. If you have any questions on this before you do the assignment or during the discussion board, as always, please let me know.